All right, we are wrapping up our conversation on the First Amendment and free speech, and I want to talk about commercial speech. In our last lectures, we talked about non-commercial speech, so the kind of speech that you and I would have in a public discourse, just we're talking with friends, we're shouting in a public place, that is protected under the First Amendment. Commercial speech, where you're engaged in a commercial transaction, is also protected, but it's got different limitations. And we have commercial speech that is non-misleading, so think advertising, think things that are truthful advertising, right? And then we have commercial speech that is misleading, untruthful advertising. And that's the easy one for us because untruthful advertising, misleading commercial speech has absolutely no protection, and the government can regulate it. Absolutely regulate it and require you to take it down. You do not get to say, you do not get to mislead the public in a commercial transaction under the auspices of free speech. Now, commercial speech that is non-misleading is a bit more complicated. In general, it's protected. We want businesses to be able to talk freely about their products and services. Now, where there is a variation on this is when the government has a substantial interest in regulating it. So we talked about in non-commercial speech, the government has a compelling interest. That's a very, very high bar. Substantial interest is a lower bar. The government just has to present essentially a rational reason that they want to regulate that speech. And if they do, they can tell businesses that they can't talk about certain subjects. So the 44 Liquormart case is our case on commercial speech that is that the government wants to regulate. So 44 Liquormart out in Rhode Island, they had they wanted to advertise the price of alcohol. And the government said that there was a Rhode Island law that said you could not advertise outside of your store, you could not advertise the price of your alcohol. And so they essentially told 44 Liquormart, sorry, no luck. So 44 Liquormart brought a suit against the state of Rhode Island to challenge this under the auspices of free speech. Now, the question then is, does the government have, we know this is commercial speech, so does the government have a substantial interest? Well, let's just get off the table that they're not misleading the public, right? They are telling the actual price. It's not bait and switch or anything like that. So is there this substantial interest by the government? Now, what you might want to think about, what reasons would you as a state have to regulate that you don't want the prices of alcohol advertised in public places outside of stores? And you might say, well, we don't want to discourage alcohol consumption. Okay, perhaps we don't want to encourage drunkenness. Okay, we don't want maybe to encourage drunk driving. So those are all substantial interests of the state, but are they connected to 44 Liquormart's advertising? I mean, is there a logical connection between these two things? The answer is probably not. The state really couldn't demonstrate a connection here. So how would the advertising outside of a building eliminate or reduce drunk driving? Or people driving by the Liquormart and saying, I wasn't going to stop in, but that thing is $1 less, so now I'm there. Maybe, but they couldn't show any evidence of that. And so the government can't just present a substantial interest just because they want to. They actually have to show some evidence. Does it actually eliminate or reduce drunkenness? Well, we don't even know that either. Probably not. Probably if you're an alcoholic, you're going to go to the liquor store and you're going to buy liquor no matter what it costs, and you're going to pay that price. You're not going to be encouraged to drink more alcohol because of the sale. So there was no, while the government had an interest, a substantial interest in regulating and reducing some factors, there was no connection between what the government wanted to accomplish here and actually accomplishing that. So there is no substantial interest that we can show. So let's look at a couple other situations where the government can regulate it. If you've ever been to Las Vegas, you've seen that there are people out in the streets and they're shaking they're shaking these little pamphlets with to advertise houses of prostitution and call girls and things. And so if you've ever wondered why are they slapping them in the air, they can't actually talk to you, they can't call out to you, they can't even hand it to you. So the city of Las Vegas wanted to eliminate or reduce the they tried to make Las Vegas a more family-friendly city, and so they wanted to reduce some of the sleaziest parts of Las Vegas, or at least not make them so visible on the Las Vegas Strip. And so instead of completely eliminating advertising on that subject, they said that you couldn't, and then they had all these people down there, that were holding out these signs and calling to people and talking to people, walking up to them. They regulated, and they said, our substantial interest is that you do not, these advertisers do not walk up to and talk to and engage with people walking up and down the streets. So they are slapping them on their hands to try to get your attention, to try to get you to take them. So if you ever go to Las Vegas and you wonder why they're doing that, is because the city of Las Vegas had a substantial interest and was able to enact a law that reduced how these individuals could advertise to the general public. You may have seen a couple other cases. Maybe you remember the airborne vitamins. They actually advertised themselves when they first came out as preventing colds or reducing the number of days of a cold. While there was no actual evidence that it did, it certainly didn't prevent a cold. It was just a heavy dose of vitamin C. So this was misleading advertising that the government was able to regulate and put an end to. We also have situations of puffery, where, and this gets close to the edges on misleading, where puffery is you are talking about your product and you are embellishing it perhaps, or saying that it's the greatest product ever created. Now, we allow you to say things like it's the greatest, it's the best, it will be your favorite. This is puffery. You're not making a factual statement. The problem is when you get into places where you can make factual statements and compare those factual statements to actual evidence. So a couple examples. Uber got into some trouble because they started making advertisements that said Ubers were measurably safer than public taxis. And the taxi companies, the taxi co-ops, sued Uber and said, you don't have any actual evidence that Uber is measurably safer. Show us where you measured it. Uber could not provide that data, and so the taxi company was able to use the courts to regulate and prevent Uber from making these advertisements. I'm sending you to a video that shows from DirecTV advertisements with Rob Lowe. And I want you to watch these carefully and try to identify places where where puffery has gone too far. These are very funny ads, and they're well done, but they made statements in them where they edged on making factual statements that DirecTV was able to provide evidence otherwise, or at least challenge that evidence didn't exist. So you can make puffery statements, you can make statements about your product to the extent that they are non-misleading, but you get into a gray area with puffery, and certainly when you can measure things and prove that they are incorrect, it becomes misleading and the government can regulate it. So that's what I want you to know. Commercial speech is protected unless it's misleading, and if it's not misleading, the government can regulate it only if they have a substantial interest in doing so.